All right, the surrogacy journey, it's just filled with so much hope. But let's be honest, it's also incredibly complex. But what if I told you one of the biggest risks you face isn't medical, but a so-called convenience that your agency might offer? Today, we're going to pull the curtain back on a huge legal red flag that could seriously put your family's future at risk. And this is the question, isn't it? It's the one that gets to the heart of the whole thing. Your agency offers to handle all the legal paperwork. And on the surface, that sounds amazing. A perfect, simple solution. But who is that lawyer actually working for? Let's dig in, because why this question matters so much is absolutely critical. Okay, so let's just be fair for a second. Why do agencies even offer this? Well, they're not dumb. They know that bundling legal services into their package is a really, really easy sell. I mean, it simplifies things for them, it gives them more control, and of course, it taps right into that deep desire every intended parent has for a journey that's just simple. And honestly, who wouldn't want that? So what exactly are we talking about here? In-house legal is pretty much what it sounds like. It means the lawyer is either an employee of or has a contract with the same agency that's managing your surrogacy journey. They draft contracts, they review the contracts, and at first glance, it seems super efficient. And look, the sales pitch is compelling. One point of contact, way less paperwork to chase down, and what feels like a much smoother path to building your family. But, and this is a huge but, this convenience can come at a really high and often totally hidden price. And that price, well, that's where we get to the core of the problem. This whole setup is built on something called a conflict of interest. And let me tell you, in the legal world, that is a massive, flashing neon red flag. I mean, just think about it logically for a second. A lawyer's number one job is to protect their client. But when their paycheck is being signed by the agency, well, their loyalty, both professionally and financially, is to their employer. That automatically puts your interests in direct competition with the agency's interests. And this breakdown just lays it all out so clearly. On one side, you have the lawyer's duty to the agency, protect the business, limit their risk, stick to their policies. But on the other side is what you need. You need someone whose only job is to protect your family, make sure your contract is fair, and give you unbiased advice. You just can't serve both of those masters at the same time. It's impossible. And let's be clear, this isn't some abstract legal theory. We're talking about real-world risks. You could get locked into a contract that's completely slanted to protect the agency, not you. And if something goes wrong, it becomes incredibly hard to hold the agency accountable. From the very beginning, that lawyer's fundamental duty to you was compromised. Now, this isn't just about what's a good idea or what's ethical. In a lot of places, the law is actually crystal clear on this. Take a look at this from California's Family Code. California has some of the most well-defined surrogacy laws out there, and it's written right in. The key words here are must and independent. That is not a suggestion. It's a legal mandate designed to protect everyone involved in this process. And hey, even if your journey isn't taking place in California, it doesn't matter. This principle is universal. Every state has rules of professional conduct for lawyers that flat out prohibit these kinds of conflicts of interest. A lawyer just can't have two masters, especially when what's best for one isn't what's best for the other. Okay, so you get the risk. It's real. But how do you actually spot it when you're in the moment talking to an agency? Let's turn this from theory into a practical checklist you can actually use. Here are 4 huge red flags. First, if you're reading the contract and it just feels lopsided, like it's all about protecting them and not you, that's a problem. Second, if they say something like, "Oh, this is just our standard agreement, no need to change it." Whoa, pump the brakes. That's a big warning sign. Third, vague details. If things like timelines, insurance coverage, or pre-birth orders are fuzzy, not good. And finally, if the lawyer seems to be communicating more with the agency than with you, well, that tells you exactly where their true loyalty lies. So, after all that doom and gloom, here is the good news. Protecting yourself is actually pretty straightforward. It just comes down to insisting on one single, non-negotiable right. This is it. This is the golden rule, the most important thing to take away from all of this. You must get your own lawyer, an independent lawyer, someone who works for you and only you. Their one and only job is to have your back. But being independent is only half the battle. They also have to be a specialist. Let me tell you this quick cautionary tale. A couple hired their own lawyer, so far so good, but he was an immigration lawyer. He missed a critical time-sensitive deadline for their pre-birth order, and the result was a total nightmare, causing a huge, stressful delay in them being named the legal parents after their baby was born. That story just drives the point home, you know? Your independent lawyer also has to be an expert in this specific field, assisted reproduction law. This stuff is complicated, the procedures are very specific, and the deadlines are no joke. You absolutely need a pro who lives and breathes this stuff every single day. So we end up right back where we started. The next time you're talking with an agency and they make you that oh so convenient offer to handle all the legal work, just pause, take a breath, and ask yourself that one simple question. Who is that lawyer really protecting? Because on a journey this important, the answer, unequivocally, has to be you.